An Introduction to Medical Malpractice in the United States. It's printed in National Library of Medicine, National Institute of Health. Discussion. The purpose of this paper was to provide an overview of medical practice in the United States and the judicial system developed to handle legal claims related to such. The concept of holding a physician accountable for medical malpractice is grounded in ancient law, and modern tort law related to medical negligence claims has evolved after the principles of English common law, modified and changed by numerous court decisions and legislative statutes that vary from one state to another. Lawsuits alleging medical negligence in the United States are usually filed in a state trial court that has jurisdiction for the case. In some cases, malpractice claims may be filed in a federal court. Medical malpractice law is a part of civil law rather than criminal statutes in the United States. And in contrast to some other countries, a jury trial is used to adjudicate medical malpractice claims, and the role of judges is relatively limited. The system is adversarial and designed to promote pre-litigation settlement of disputes between parties. Extensive legal tools, such as depositions of parties to the litigation, have been developed to encourage litigants to discover facts, assess the merits of their arguments, and hopefully reach independent resolution of the case. Few cases will actually make it to trial. To show that medical negligence occurred, the aggrieved patient must show that a duty of professional care existed and that such duty was breached when the physician deviated from the standard of care. And as a result of such breach, there was an injury, and that such injury is measurable in damages that the court can use to calculate the redress owed to the plaintiff. These legal elements of a medical malpractice case must be proven by the patient suing the doctor, so the applicable standard of proof required by law. The contingency fee system of compensating plaintiffs' attorneys have been criticized as promoting litigation, while some meritorious claims that may have a low probability of financial reward may never get filed. Defense lawyers are usually appointed by the physician's insurance carrier. Both the direct cost of medical malpractice that are related to insurance premiums and administrative costs and indirect costs related to altered physician behavior in the face of threatened litigation are significant. Many efforts at tort reform have been directed at the state level as well as federal level in the United States, with the goal of improving the system and reducing litigation-related costs. Other nations have developed similar systems of adjudicating medical malpractice claims with some notable differences. Comparisons among systems may be helpful in identifying future reforms in the U.S. medical malpractice system. In summary, as technology and the demand for health care have increased, the complexity and incidence of healthcare delivery, injuries, and adverse outcomes require a system of patient redress that is equitable, fair, economical, and just. The United States has an adversarial system of adjudication of medical malpractice claims similar to the methods of resolving other civil disputes. Physicians are typically unaware of the intricate logistic structure and functioning of the legal system until faced with a lawsuit alleging medical malpractice. Even a jury verdict in favor of the defendant physician can take a heavy toll in terms of personal stress, discouragement, and time commitment to the process. The experience of other developed nations around the world suggests that there's no simple answers to address medical malpractice, and future reform efforts will continue to develop a system that's economically efficient and adequately compensates those injured by medical errors, while excluding frivolous and opportunistic medical claims.